Building upon our understanding of contiguous land and how parcels relate to one another in ownership and use, we now turn to another key concept in Arizona real estate law: prescriptive easements. While contiguous land focuses on physical and legal adjacency between properties, prescriptive easements address how a person may gain a legal right to use another's property over time without owning it. This topic closely parallels the doctrine of adverse possession discussed earlier, but with one critical distinction. Adverse possession transfers ownership, whereas a prescriptive easement grants a right of use. A prescriptive easement is a non-possessory legal right to use another person's land that is acquired through continuous, open, and adverse use over a statutory period. In Arizona, the governing law is found in ARS paragraph 12-526 and the state's common law tradition, which together require that a claimant demonstrate use that is open, notorious, continuous, hostile, and under a claim of right for at least 10 years. This mirrors the elements of adverse possession, but does not require exclusivity or ownership intent. In Arizona, there is no single ARS section that expressly defines or creates a prescriptive easement. Instead, prescriptive easements are recognized through case law and are derived from Arizona's adverse possession statutes, primarily found in Title 12, Chapter 5. To illustrate, imagine a rancher who has, for more than 10 years, used an unpaved road across a neighbor's property to move livestock and access a water source. If that use has been consistent, visible, and without the landowner's permission, the rancher may acquire a prescriptive easement, essentially a legal right to continue using that roadway indefinitely. The ownership of the land does not change hands, but the property becomes burdened by the easement for the benefit of the user. The Arizona Supreme Court has repeatedly affirmed the requirements for prescriptive easements in key decisions, such as Spalding v. Polio, 2009, and Cheatham v. Vanderway, 1987. In Spalding, the court clarified that prescriptive easements must be based on use, not possession, and that mere neighborly accommodation or permissive use cannot ripen into an easement by prescription. The ruling emphasized that the use must be adverse, meaning without the express or implied consent of the property owner. Similarly, in Cheatham v. Vanderway, the court upheld a prescriptive easement where the claimants had openly and continuously used a roadway for more than 10 years to access their ranch. The owner of the burdened property argued that he had merely allowed the use, but the court found that no explicit permission had been given and that the use was sufficiently adverse and visible to satisfy the statutory requirement. This case continues to serve as one of Arizona's most cited precedents in boundary and access disputes. The court held that mere long-continued use, standing alone, is not enough to establish a prescriptive easement when the original use was permissive. This case is frequently contrasted with Spalding v. Polio, as Cheatham emphasizes that permission defeats hostility and that the burden remains on the claimant to show when and how permissive use converted into adverse use. A prescriptive easement can exist for various purposes, including driveways, irrigation ditches, grazing paths, utility access, or even recreational trails. However, the scope of the easement is limited to the specific use that was established during the prescriptive period. For instance, if a prescriptive easement arises for vehicle passage, it cannot later be expanded to allow for commercial trucking or the installation of utility lines without mutual agreement. An important distinction in Arizona law is between permissive use and adverse use. If a property owner gives permission, either verbally or through written license, the user cannot later claim a prescriptive easement. Courts in Arizona interpret permission broadly. Even informal statements, such as, "You can use my road anytime," are enough to defeat an adverse claim. In this sense, property owners can protect their rights by granting revocable licenses to neighbors, thereby preventing future prescriptive claims. Real estate professionals must also be aware of how prescriptive easements affect title, disclosure, and land value. Because prescriptive easements are created by use rather than written agreement, they often do not appear in recorded title documents. A title report may not disclose their existence, but the easement remains legally enforceable if proven in court. This can complicate transactions involving rural or undeveloped properties. Brokers representing buyers should recommend physical inspections and surveys to identify potential paths, fences, or irrigation ditches that indicate long-term use by others. Sellers have a duty to disclose any known easements or disputes that could materially affect the buyer's use or enjoyment of the property. An example in practice might involve a buyer purchasing a 40-acre parcel outside of Florence, Arizona. Upon taking possession, the buyer notices that a neighboring ranch regularly drives across a dirt trail running through the property. The seller, aware of this but silent about it, may be found liable for non-disclosure if the buyer later learns that the rancher's use is protected by a prescriptive easement. In this case, the buyer would be unable to block the rancher's continued use without a court ruling to extinguish or relocate the easement. Prescriptive easements can also influence land development and zoning. If a developer plans to build over an existing path that has been used by the public for years, local governments may require proof that no prescriptive rights exist before approving site plans. Developers may need to negotiate releases or alternative access routes to prevent legal challenges after construction. Courts may also terminate or modify prescriptive easements under certain conditions. For example, if the easement has not been used for an extended period, known as non-use or abandonment, or if the dominant and servient owners reach a mutual release agreement, the easement may be extinguished. However, abandonment requires both non-use and intent to relinquish the right, which can be difficult to prove. Review summary. A prescriptive easement allows a person to gain the right to use another's land after continuous, open, and adverse use for 10 years under Arizona law. It differs from adverse possession in that it grants usage rights rather than ownership. The claimant must prove that the use was visible, hostile, and without permission. Real estate professionals must identify potential prescriptive easements during due diligence, as they can impact property value, access, and marketability. Awareness of these rights helps prevent disputes and ensures proper disclosure in transactions involving rural or undeveloped properties. Discussion prompts. What is the main difference between adverse possession and a prescriptive easement? Answer. Adverse possession transfers ownership of land, while a prescriptive easement grants only the right to use it. Why is permissive use a defense against prescriptive easement claims? Answer. Because the law requires use to be hostile or adverse, permission from the owner eliminates the element of hostility. What are some examples of features or uses that might indicate a potential prescriptive easement? Answer. Dirt roads, irrigation channels, fences, or paths that have been used consistently by others for years. Closing remarks. Prescriptive easements demonstrate how long-term patterns of land use can shape legal rights, even without written agreements. For real estate professionals, understanding these principles reinforces the importance of diligence, observation, and full disclosure in every transaction. When representing buyers or sellers of rural property, taking the time to identify potential easements can prevent costly legal disputes and protect client interests. This topic ties back to the fundamental principle of Arizona real estate law: clarity of ownership and responsible stewardship of land use. Supporting sources and key case law. ARS. Paragraph 12, 526. 10-year statutory period for adverse use and prescriptive easements. Arizona has no ARS section titled or devoted to general provisions governing easements and rights of way. Those rules come primarily from Arizona case law, with statutes providing only limited and indirect guidance. Cheatham v. Vanderway, 718 P2D 955. Arizars, 1987. Elements of open, notorious, and continuous use. Spalding vs. Pulio, 218 Rs. 196, 2009. Clarified distinction between permissive and adverse use. Etz vs. Mamero, 72 Rs. 228, 1951. Recognition of prescriptive easements for long-term roadway use. But it must be necessary AAC. R4, 28, 1B. Licensee duty to disclose known easements or property defects.